short statutes, time sensitive, and so people are aware of that.
So Brian, what do you make of all this? No, I mean, it just didn't, your practice, have you had any problems in terms of bringing information forward because of the one bite rule, or like how do you see the changes?
Well, I think the
program?
The CI, the criminal investigative arm, does operate completely differently, and Steve brought up a very good point that they're usually, at least in investigations that are mature at all, they're usually with an assistant U.S. attorney. And so those cases are run much more like traditional criminal investigations that are run by the FBI or the DEA or anybody else, and are much more similar to what we're used to as False Claims Act lawyers. And actually, the level of interaction there is greater than we're used to as false claims lawyers, because they're active criminal cases, and there's, like Steve has said, these guys are trained in the U.S. Attorney's Office. They're used to working with informants and witnesses on an ongoing basis, and they're very familiar with the Fourth Amendment concerns about the current employee. So a lot of our current employee cases have gone for whatever, because the active fraud cases have gone through CI. And you don't run into these as many of the taint issues, I would say, and they're kind of handled by the assistant U.S. attorney. And they're not that much dissimilar than any, attorney-client privilege issues or other issues you have in any criminal investigation. When it's on the civil side, I would say the taint process, that review is a really critical, from what we've seen, is a really critical part in the process, and it's a place where lawyers can really earn their keep and can provide a valuable service, because the General Counsel's office is looking at a variety of issues, and I think Steve had said earlier, at least from the Whistleblower's office view, you're looking at attorney-client privilege issues, and then, at least the Whistleblower's office may not be as concerned with other privilege issues, but what we've seen is the General Counsel's office is concerned about other privilege issues, that they look at, account client issues, tax preparer issues, even some confidentiality issues, and they're trying to do an analysis, of what is legally prohibited or legally they're allowed to do. But there's also a lot of, and I'd be interested to get Miriam's input or take on this, but my sense is there's a lot of discretion and cost-benefit analysis going on here. That the IRS has often been criticized for not being aggressive enough in some enforcement with tax abuse shelters and offshore, but they're also been criticized for being too invasive. Steve referred earlier to they're not jackbooted thugs, because the IRS has been taking a task for being too aggressive, and there's a reason why they weren't part of the False Claims Act, because it's viewed as being much more evasive than traditional types of investigation that's conducted by the government. So I think, and I'd be interested to get Miriam's take, but I think, they're very concerned about not trampling on taxpayers' rights, and so they don't want to be accused of using improper documents. And I've seen the analysis go, and we've had some very good back and forth where General Counsel's office will contact us and say, look, we have a concern about this account-client privilege issue. And we'll go back and forth in the law and state our position as to why we don't think something's privileged or why it is. I think, as practitioners, we should probably be trying to anticipate all those issues and prophylactically in your submissions, identifying what you think could possibly be an issue and laying out the law and the facts, particular facts, because we have a concern that maybe we're not always being told what the concern is of the General Counsel's office, and they may have an issue with something that we've submitted that we didn't even that you didn't identify, and documents could not go, maybe not go forward, or a case could not go forward, and
there's lots of discretion here too on their part on whether to do a case, right? I mean, even if there's a violation, if they're concerned about, you know, the nature of the documents and is it really a little bit sticky, and you know, the General Counsel does a memo that says, you know, this is a difficult, you know, your case might, you know, fall by the wayside, and even when it gets sent to the operations department, right? I mean, they have audit plans, and you know, they can, you know, they're not going to get to every case. So the more problems there are in your case, I think the more, you know, the IRS is less likely to go forward. So I think, in terms of the taint process, for us it's been very important because often our critical documents are coming from people that have an accounting function, we've had cases we think that have gotten held up for a long period of time, I think, wrangling with these document issues. So I think that's a critical part for us to play and determine what we want to even give to the IRS, because you want to avoid these problems if you can, because it slows down the case. And then to, as much as you can, anticipate and explain your submissions why they should use the documents.
How about that, Miriam? Is it beneficial from your perspective when you have a portion of the submission dedicated to an analysis of whatever taint issues there may or may not be in the case?
I think that would be very helpful. Certainly identifying documents which might be problematic. I mean, just providing a, you know, potential privilege log, if you will. Certainly explaining the nature. I mean, if you have an informant who is an attorney who at one point represented the taxpayer, it would be very beneficial to outline the scope of that representation, because, you know, maybe the attorney never represented them in a tax matter, or they represented them in a tax matter, but it was 20 years ago and it had nothing to do with this one. I mean, all of those, I mean, once you identified that there was at some point an attorney-client relationship, it's very important to tell us exactly what the scope of that relationship was.
And I think the critical thing as Whistleblower Counsel is to try to anticipate as much, I know I've said this, but to try to anticipate, because you're not necessarily going to get a call from the General Counsel's office. They see things like taxpayer representatives, and that's a red flag if they ever were. Lawyers, even in-house accountants. So it's always a concern of ours, you know, have we looked through everything and identified everything that could be a problem? Because, you know, sometimes we get calls about issues, but I suspect that sometimes we don't get calls about issues where they're identified as problems. So you really want to be careful about reviewing everything that you turn over for any potential pitfalls, and to do a very good job of laying out what your analysis is.
Yeah, there are two competing concerns, right? We're being asked to present all the information, and the form tells us to give you everything we've got, and you know, otherwise it might not be considered, or you may not be, or your client may not be rewarded for that information. But on the other hand, it seems pretty clear, just in practice, that with the volume of these cases and the limited resources that are available in the part of the service, that giving a mountain of paper can be potentially a problem in a case just to get it through taint, because you folks have to look at it. And I guess, you know, with that reality, does your office find it sort of, I guess it's easier to deal with a tighter submission, but you know, do you have any thoughts on that, one way or the other?
I guess the important thing is organizing the documents. If they're well organized, I've seen some practitioners provide summaries, which are helpful in terms of pointing us to, you know, the different types of documents. Again, the more complete the information and the more organized the document, documents, the quicker things will go.
And introduce, very similar to what you do in False Claims Act cases, the submissions will, highlight and analyze the hot documents, and then